appeal in the matter of the Major and Burgesses of the London Borough of Islington and the personal representatives of Seals and A&R.
Yes, Miss Davies.
My
I can
lords,
tell you that we've read the skeleton arguments and the judge's judgment.
I'm very grateful for that. My lords and my lady, I appear for, in fact, the appellant, who is the second defendant, Ms. Abdelrahman.
Yes.
And Mr. Gannon sits behind me, and he appeared in the county court. The respondent is represented by Ms. Salmon, and Ms. Davis sits behind her, and
yes.
Ms. Davis appeared in the county court, so neither Ms. Salmon nor myself appeared. Just on housekeeping, my lords and my lady have a core bundle, a supplementary bundle, and a bundle of authorities.
Yes.
And my Lord Justice Lewison asked for additional dictionary definitions.
Yes, which we've also got.
And we paginated them so they can be
Yes.
added to the end of the authorities bundle. I'm grateful. My lords and my ladies, as you know from having read the skeleton and the judgment, this case concerns interpretation of section 113 of the Housing Act 1985.
Does it?
Well, does it?
Doesn't it concern the interpretation of Islington's policy?
Well, Islington very clearly tied themselves to the mast, as it were, of section 113. That's a very bad expression. I'm sorry for that.
Well, I'm not sure about even that. Islington's policy is certainly based on section 113. But there are differences. Just to give you one difference, section 113 entitles a family member to succeed if they have been residing with the tenant for 12 months. Islington's policy, and that's why the appeal failed in, is it Turley?
Turley.
Because the woman hadn't been living with her partner for the requisite period.
Yes.
Islington's policy allows you to succeed if you've been living in the property for 12 months. So there's one difference. Doesn't require you to have lived with the tenant.
My lords, we should go to the policy.
Yeah.
In that case, and because my lord made the point so quickly, it's supplementary bundle, page 48.
Yes. But I entirely accept that it is based on section 113.
Yes. And more to the point, my lord, it's been Islington's case throughout, and I can take my lords and my lady to the references in the respondent's skeleton and in the judgment, that the interpretation of the policy depends on the interpretation of section 113. Again, I'm paraphrasing from that, but I say that has been clearly Islington's position. I do acknowledge that if this was simply a policy in Islington's allocation scheme, they're entitled to do under section 86A, that provided it different categories of who might succeed, then we might be in different ground, and it would be a public law matter about the rationality of the policy and the rationality of the decision making. But what I say, and we can go through the reference in a moment, is that Islington have clearly said, we have adopted section 113, we'll look at the differences, but we have adopted section 113, and our interpretation of the policy is consistent with the interpretation of section 113. And in the county court below, that was very clearly their stance.
Do we know when the policy was adopted?
The policy that we're looking at says that the change takes effect from the 1st of July 2013. That's page 48 of the supplementary bundle. My lords and my lady will know that the flexibility at section 86 of the Housing Act 1985, permitting local authorities to adopt their own policies on succession outside of spouses and cohabitants, came into force in respect of tenancies granted from the 1st of April 2012 onwards. Exactly when it was adopted, I can't help, but we know that the policy says the change takes effect than the 1st of July 2013.
Might there be an intermediate position, Ms Davis, which would be that Section 113 is a guide to the interpretation of the policy, but it's the policy and Section 113 are not the same thing.
Well, shall we come back to whether they're the same thing in a moment? But again, and at the risk of sounding like I'm repeating myself, I say that throughout these proceedings that has not been Islington's position. Islington's position before the judge was that she had to interpret Section 113.
Yeah.
And that it was her interpretation of Section 113, which we are appealing, and it was not said before her that her interpretation of Section 113 didn't matter. What mattered was the interpretation of the policy. That was not Islington's position. Obviously, Ms Salmon will correct me if I've misunderstood that. So, my lady, yes, that might be an intermediate position, but it hasn't been the position.
And you say it's not open to Islington to argue that, or not open not open to us to decide that?
I'm aware that we do need to look at the differences in the succession policy from 113, and I do want to come back to that. Yes, I do. And the reason I do is because of the judgment and then of the grounds of appeal. So the judgment, which is at page 73 in the court bundle. Page 7, I'm cherry picking, but I hope I'm not doing so in a misleading way. Page 79, paragraph 31, Miss Davis's submission. Miss Davis responded that the discretionary policy replicated the statutory scheme before the Localism Act 2011. The statutory scheme before the Localism Act 2011, as I understand it to mean. And the court should be guided by the case law, that might be the then case law, who knows, in relation to the statutory provision. She says, in order to interpret the policy, the court must consider how previous courts have interpreted the section, what the purpose of the policy is, and how to apply it in this instance. And then she goes to Sheffield and Wall. Over the page, she goes to Michalak.
Yeah.
And at paragraph 34, just as the purpose of the statute was intended to be an exhaustive list and to have a restrictive purpose, Miss Davis said the policy is intended to replicate the same. And the court, this is Islington's submissions, the court should interpret the policy as it would interpret Section 113.
Well, that might be consistent with the point I put to you a moment ago.
I'm sorry, my lady, I'm having difficulty hearing.
That might be consistent with the point I put to you a moment ago.
That it's guidance.
Well, that it's a guide to the interpretation of the policy. They're two different things, aren't they?
Well, Islington's position is that Section 113 doesn't include the definition of stepchild that we contend for. No, that is their position. They don't go on to say, even if it does, we've chosen in our policy not to adopt the definition, which they could do.
Yes.
I accept they could do. But that is not their case. In terms of whether or not it is open to this court, first of all, the judge herself made a decision on statutory interpretation and on the policy. I accept that, and that's paragraph 50 at the top of page 83.
Sorry, paragraph
50 of the judgment.
50. Yeah.
She says it's quite clear that the Act, that's Section 113, and the policy did not intend to engage in qualitative assessments of this nature when identifying who was a child or any of the categories under Section 113(2). I'm satisfied that applying the case law and considering the purpose of the policy in the context of housing resources such a limited, the council did not err in considering that Miss Abdelrahman was out with the policy. So she does find a clear interpretation of Section 113. She then, I accept, applies that to the policy. But as I have said, there is a danger of repetition. It was not Islington's case that they
No.
had considered section 113 and they had chosen to apply some or all of it. And their interpretation of section 113 was a matter for them that could only be challenged by public law.
But can we just take this in stages? Your case is that Miss Abdelrahman was entitled to succeed under the policy, not under section 113, because section 113 didn't apply.
It can only be under the policy.
Yeah, because
yes.
the section 113 didn't apply to Mr. Seal's tenancy.
Yes.
So the ultimate question is, what does the policy mean?
Yes.
And there is plenty of case law about the interpretation of documents, which says very clearly that the court is not bound by concessions about what it means, agreement about what it means. The court must decide for itself what the disputed document means. Now, why does that not? I mean, it's true that those sorts of cases are mostly contract cases, but why does that not apply to the policy?
There's a practical difficulty for this court in that the only evidence before the court as to Islington's interpretation of its policy is it stamps that it replicates section 113.
Yeah, but subjective intention wouldn't be relevant, would it? I mean, we've got to interpret the policy as a document. It's semi-public, at least, because it's there as the local authority's policy guide.
It is public. It's part of the allegation.
Right. Okay.
Yes.
So it's public. So what Islington thinks is, in a sense, neither here nor there, is it?
Well, it's here or there in that the starting point on a policy is how Islington interprets it.
Right.
It's an allocation scheme, and therefore, on that basis, we're into public law principles. You start with Ahmed and Newham, that it is a matter for the local authority, and so forth.
There's I'm sorry to interrupt, Sue. There's lots of case law that says that the interpretation of the policy is a matter of law for the court.
In the allocation side of things, the starting point with Ahmed and Newham is that the interpretation of policy is for the council. And
what level is Ahmed and what?
Ahmed and Newham is 2009. I'm sure my learned friend can get the exact reference. I know my Lord Lewison will be familiar with it. It was.
Can't say it springs to mind immediately, but
okay. It was an issue about whether or not Newham's allocation scheme had complied with the provisions of Part 6 of the Housing Act, which provide for certain means of organising an allocation scheme in terms of preference to be given to certain groups and so forth, and whether Newham's policy was out with those statutory provisions. And the House of Lords gave a very firm judgment to the effect, and this is paraphrasing, that decisions within local authority allocation schemes were for the local authority as the locally elected body and so forth, that the court would be very reluctant to intervene, and broadly would only intervene if it was when to be unreasonable, irrational,
right.
or alternatively clearly outside the requirements of Part 6. So if on the this is allocation. The discretionary succession falls within allocation, and therefore the starting point is it's for Islington to determine both the application and to interpret its own policy.
That's just inconsistent with the Supreme Court authority, which says that the interpretation of the policy is a matter for the court.
My lady is thinking of.
Oh, I can't remember the name of the case off the top of my head.
Well, Tesco and
Dundee,
is it?
yeah.
I mean, there's a huge body of law in the realm of town and country planning, which says again and again and again that the interpretation of a policy is a matter for the court.
Planning policies.
Yes, but why should housing policies be any different?
Because, as I said, there is Ahmed and Newham, where
Right.
that is the starting point. And if I've misremembered it, then I will check as soon as I can.
Okay.
Is it in the bundle while I'm making this?
No, because it's
No,
that's
so
not.
I think
how
I'm
this
afraid
case
we've
is.
sprung this point on you, Miss Davis.
Sorry.
I'm afraid we've sprung this point on you.
I can give my lords and my lady the reference now, if that.
Yes, that would help.
Please.
It's 2009 UKHL 14 and 2009 Housing Law Report 31.
Right, thank you. Right.
Right. So my lords and my lady, I do say that Islington's case throughout has been that the proper interpretation of the policy is in accordance with section 113.
Yes.
But perhaps we can turn to my lord's point about the differences. So it is supplementary bundle, page 47 and 48.
Yeah.
And section 113, in its current iteration, is in the authorities bundle at page 16, but it may be better to look at the iteration that was in force when this policy was drawn up, and that's page 15, the authorities bundle.
15, yeah.
15.
And am I right in thinking that section 113 continues to apply to tenancies granted before whatever the date was,
1st of April 2012, yes.
And it's also still in force in Wales?
I'm sorry, say that again?
Is it also still in force in Wales?
No, it looks as though it is from the way that the sections are laid out, but the Renting Homes Wales Act 2016 repealed what was then section 87, which did apply to Wales. Broadly, the scheme in Wales is the same as excuse me, the current statutory scheme, in that spouses, civil partners, and those who are cohabiting, I'm going to use that word for the moment, with the deceased tenant, have priority succession, so they have a right to succeed. And then there are reserved successors which a local authority can adopt. So it's a similar scheme to the modern English scheme. But my lord is right in that it took some time to come into force. So my lord, the changes are at page 48.
Yeah.
And the starting point is changes to the law that took effect on April the 1st, 2012, limited the right of succession to a smaller group of relatives, namely a joint tenant, a deceased tenant's spouse or civil partner, that is equivalent to the married partner of the deceased tenant, partners of the opposite or same sex, that is the unmarried, heterosexual or same sex partner of the tenant. So that policy does not state that those three categories who have a statutory right to succeed must be living with the tenant at the date of death, but those three categories have a statutory right to succeed under section 86A, which Islington could not exclude. So that part of it is, as it were, for information rather than a policy.
Yeah.
So then we go on to the following residents would no longer have an automatic right to succeed, but the council would allow them to succeed if they've been living in the property for 12 months before the date, before the death of the tenant. And that's my Lord Justice Lewison's point, that is not compliant with what used to be
Section 87, isn't it?
Section 87,
Yeah.
which said he's resided with the tenant throughout the period of 12 months prior to the tenant's death. And I cannot help you on why there is that change. Clearly, I'm not for Islington.
No. Well, then there is, but there it is.
There it is. And the property is suitable for their housing needs, has the correct number of bedrooms. Clearly, they're entitled to come to that decision. And then the list, unless I've misread it, the list of parent, grandparent, child, grandchild, brother, sister.
Brother and sister has been changed to sibling.
Sibling.
That probably means the same thing.
I think it means the same thing, yes. Uncle and aunt, uncle or aunt, nephew or niece, and they've added in half brother or sister, which comes from section 113 to B. And then there is reference to what can only be the case of Sheffield and City Council and Wall, that a foster child is not counted as a child for person of succession, and that only blood relations, including stepchildren and illegitimate children, should be considered for succession in the future. So that
So a
deals with-
stepchild isn't a blood relation of the step-parent.
No,
So it's another oddity in the
it's
policy.
another oddity, which I can't help my lords and my lady with. But the one difference, which I'm grateful for my lord having pointed out, is whether it's residence in the property or residence with the tenant. And again, I accept Islington are entitled to make that change, and they could have cut down the list. They could have decided that relatives were not entitled to succeed in any circumstances. They could have extended the list and included, for example, foster children or carers or anyone else who might have a claim. And they could have either restricted or extended the 1 year residence period. They could have changed it to a longer period, or they could have changed it to a shorter period. And that was the purpose of the Localism Act, amending and inserting Section 86A to provide flexibility to local authorities. So I do accept that, but I come back to my point that throughout these proceedings, Islington's stance has been that this is about interpretation of Section 1.
Yeah.
I was going to make a number of introductory points and then turn to the facts, if I may. The first introductory point, insofar as we are dealing with Section 113, and I don't want to lose that, but as I say, that has been the party's position. The reference to stepchild in Section 113 has never been defined. It's not defined in the Housing Act. It's never been defined in case law under the Housing Act, or so far as we're aware at all. Obviously, we've looked. And it's not defined in Islington's policy, other than referring to it as a blood relation. So there is no authority, therefore, requiring this court to reach a certain result. We do not say that defining stepchild as including a person whose biological parent was living with the deceased tenant as if they were a married couple. And that is the proposition that we contend for. The stepchild includes.
Sorry, just say that again.
Yes.
The stepchild includes the child of a person.
A person's biological parent who was living with the deceased tenant as if they were a married couple or civil partners. And I take that formulation from Section 86A, which for the first time gave cohabiting partners in that position, in the position of the definition I've just read out, the same rights as that of spouses or civil partners. So the wording I've just read to my lords and my lady comes from Section 86A.
Right. So that's not the definition in the online dictionary that you relied on before the judge.
It's not no. We say the clearer definition is to equate it with the definition of what I could broadly call cohabiting partners,
Yes.
for the sake of being less wordy, but that's not the cohabiting partners is not the legal phrase I want to use, but broadly call it, that the best definition is in Section 86A.
And that came into force when?
1st of April, for new tenancies on granted on or after the 1st of April.
Well, can I ask you a different question?
Of course.
According to the judge,
Yes.
paragraph 4, well, 3, she says the factual issues were no longer disputed. And then she sets out from paragraph 4 onwards the agreed factual background.
Yes.
There is no finding that Miss Patel and Mr. Seals did live together as husband and wife. Or indeed that they cohabited. There is a finding that they had separate addresses. She had her own property in Luton and he lived in Islington.
Yes.
So if your definition, let us suppose your definition is the correct definition, that doesn't fit the facts as found, does it?
Well, the part of the difficulty with that is that there was no fact-finding exercise.
Well, yes, because it seems from the way the judge approached it that there wasn't any dispute about the facts.
No.
We don't have an agreed statement of facts. We do have a number of witness statements.
Yes.
But we don't have an agreed statement of fact.
So the witness statements from my client and from her mother, Ms. Raksha Patel, say that from about 2011, they lived together as a family.
Yes.
At the 2 different addresses. Mr. Seals' tenancy was granted in 2015, but he'd been a tenant of other property in Islington before that. So they say that, and it is therefore their case that Miss Patel and Mr. Seals were living together as if they were a married couple. That's their case. And the witness statements were prepared on that basis. Shortly before trial, the issues were narrowed, and Islington made it clear that that there was no need for evidence to be called. They didn't intend to cross-examine any witnesses. And as a result, there are no disputed facts for the judge to find. And so we say on the evidence in the witness statements contained was supported by a statement of truth and not subject to cross-examination, that is sufficient to fall within the definition that we contend for.
Right.
But I recognise the point, and what I say is this: is that if that's the only point that this court is concerned about, then normally the proper course of action would be to make the declaration that I seek in terms of definition of a stepchild, and then remit that back to the county court for fact-finding in terms of this particular relationship. But in these circumstances, I would ask the court not to do that on the basis that this wasn't a piece of evidence that was disputed. It wasn't a finding of fact that the judge came to having heard evidence, and that finding of fact then be subject to an appellant or a respondent's notice.
But that, you see, that also raises a difficulty in terms of the way the case was put below. Because if you look at the judgment again, paragraph 20 on page 76, Mr. Gannon's argument seems to have relied on the online 2023 Oxford English Dictionary definition. The definition is then quoted, and the argument is that by this definition, the word includes the child of adults in a relationship, regardless of whether those adults are married or have a civil partnership. So in the way the case was put below by on behalf of Ms. Abdelrahman, wasn't necessary for the judge to make a finding whether they did or didn't live in together as husband and wife, because that was not the way the case was put.
But she doesn't then find for Islington in terms of upholding the claim for possession on that basis. She finds for Islington on the basis that the the submission put forward by Mr. Gannon that Miss Abdelrahman is a stepchild, not a de facto stepchild, but in modern understanding a stepchild, and in fact that is an end of the matter, that she rejects that submission. She doesn't say, I reject it because on the evidence, then the relationship between Miss Patel and Mr. Seals does not amount to Miss Abdelrahman becoming what's being called a de facto stepchild. She doesn't say that.
No, she doesn't, because that wasn't the way the case was put.
Because it's not. It wasn't argued, and it wasn't in dispute. So then, the nature of Mr. Seal and Miss Patel's relationship was not in dispute. It has to be taken from their witness statements, and it is not in the judgment that the reason why Miss Abdelrahman cannot be considered a stepchild is because, as it happens, their relationship consisted of living together in two different addresses. That wasn't an issue before the court. And I can draw your attention to the respondent's skeleton argument before this court, which is page 44, bottom of page 44 in the full bundle. Right at the bottom, paragraph 11, the second sentence, there was and is no factual dispute between the parties about the substantive nature of either the appellant's or the appellant's mother's relationship with Mr. Seals. Now, Miss Salmon might say, wouldn't surprise me that she said, there's no dispute about the relationship, but there remains a dispute about whether or not that relationship fell within the definition of stepchild that I'm now contending for. But that was not an issue. It's not an issue in the respondent's skeleton.
It wasn't an issue raised by the statement of case. Look at page 97, which is the defence. Paragraph 10B. Sorry, 10C.
The meaning
That's the case that Miss Abdelrahman was putting forward.
a child of one's partner by a former relationship.
It wasn't tied to an allegation that her mother and Mr. Seals were living together as husband and wife. That wasn't an issue. It wasn't the way the case was put.
It's clearly the way. What the evidence shows.
Well, that may be, but you say there was no dispute. Well, there's no dispute because whether Miss Patel and Mr. Seals were or weren't living together as husband and wife wasn't relevant on the way the case was pleaded. So there was no need to inquire into any of that. Had the case been put in the more restrictive way that you are putting it, it might well have been necessary to inquire whether Miss Patel and Miss Abdelrahman's account of the relationship between Miss Patel and Mr. Seals was or wasn't correct, but it didn't matter.
If my lords and my lady turn back one page to page 95.
Yeah.
4A.
Yes, I see that, but it wasn't a relevant issue because of the way the case was put in paragraph 10.
It also wasn't a relevant issue, the issue of Miss Patel's relationship with Mr. Seals, because no point was being taken on it. And as I say, what was accepted was the substantive nature of Miss Patel's relationship with Mr. Seals. It's also in the judgment.
But why would a point have to be taken on it if it wasn't relevant?
Well, that was Islington's point. Islington's point was Mr. Patel and Mr. Seals were not married.
Yeah.
And that's the end of the matter.
Yes.
That was their case.
Yes.
And that's then pleaded in the reply and so forth.
Yeah.
And that's what the argument was in front of Her Honour Judge Bloom.
Can I ask you this? If you look at paragraph 4A on page 95, it does say they lived together as husband and wife from 2012, but it also says that Miss Patel later ceased to reside at the premises.
Yes.
So
And
If
I was
the
going to
que-
read that to my lords because I didn't want
Yes,
that
so
to be
if-
lost.
If the question is whether they were living together as husband and wife on the day he died, which is 2018, this would seem to suggest that that wasn't the case. And it's true that the evidence says we live together as husband and wife,
Yes.
but it doesn't directly say I was living in the flat. There's evidence from the mother, and I think also from the daughter, that there was a stage at which they moved between both properties, both in Luton and in London. But
Yeah.
one doesn't get a clear picture as to what the position was towards the end of Mr. Seal's life, apart from the fact the daughter had moved in permanently with him.
Yes.
And that rather suggests that the mother hadn't moved in permanently with him, and we know she had her own property in Luton. So I entirely accept there is evidence that they lived together as husband and wife. It doesn't seem to me to be clear evidence. And this picks up with my Lord's point that had it been identified as a critical issue, one might have expected it to be explored, that Miss Patel was living with Mr. Seals at the end of his life. And it's not obvious that is the effect of the evidence.
So several points. First of all, just in terms of dates, he dies in March 2021.
Yes.
Not 2018.
Sorry.
That's perfectly right. Secondly, the proposition that I read out, that I contend for, definition of stepchild, includes a person whose biological parent is living with the deceased tenant as if they were a married couple. We haven't explored it, but I would not say that meant that, if we take this family example, Miss Patel had to be living with Mr. Seals at the date
Living with doesn't mean
at
living.
the date of his death. I'm sorry, at the date of his death. It does mean living with. And I say that because if Miss Patel had been married to Mr. Seals, we wouldn't be here.
Yes, but marriage is a status
Yes.
which, if you qualify for, you qualify as a statutory successor,
Yes.
regardless of whether you're living together or living apart.
But I'm sorry, I didn't mean to interrupt. That absolutely. If Miss Patel was married and if she applied to succeed, then subject to the issue about whether she was living in the property at the date of her death, she would have a right to succeed. But more to the point, if Miss Patel was married to Mr. Seals, living in Luton, if that's the case, but her daughter is living with Mr. Seals,
Would be entitled to succeed.
She's entitled to see-
as a stepchild.
Yes.
Because again,
Yes. So that's why we wouldn't be here.
exactly.
Yes. So where Miss Patel, on those circumstances, where Miss Patel as the spouse, on the hypothesis that they're married, is living at the date of Mr. Seals' death, is not the point. The point is where, if they were married, where Miss Abdelrahman is living at the date of his death and for the previous year.
But the definition you adopted from Section 86A
Yes.
uses the words biological parent living with the deceased tenant as if they were a married couple. And just looking at those words on their own, one would expect that to require them to be living together, and that if they were living in two separate properties, then you didn't qualify. And then that raises a different question, which is, when do you test this? Is it at any time in their relationship, or is it at the time of the death? You would have thought, as this is a question of succession, it would be at the time of death. And one can see, this is really just echoing my Lord's point, that since this was not identified as a relevant issue, it raises a whole host of other questions which are simply not explored at trial.
Yes. And as I said, I mean, I am aware of the problem of that as the factual background. I'm aware of that, and I say if that's the difficulty, then my lords and my ladies should make declarations to the point of law, and remit it back to the county court for the county court to make findings of fact on the evidence. It's not something I press. Particularly given Islington's stance throughout that hasn't been an issue. It is not something I press. But if that is the obstacle in obtaining a declaration on the point of law that I seek, then I say the way to overcome that obstacle is remitting it back.
Well, I mean, the trouble is you're expected to put forward your whole case at trial, aren't you?
And we did. We put forward the witness statements and they were accepted
Yes,
as a factual account.
but I think, if one's being technical about it, what you're actually trying to do is raise a new point of law on appeal, which was not run at trial, because there's a different way of putting the interpretation of what was run at trial. And my understanding of the usual principles is that new points of law can be run on appeal, provided all the facts relevant have been found. And if all the facts relevant haven't been found, it's much more difficult to do so.
My lords, the grounds 1 and 2 of our grounds of appeal, which are the statutory interpretation point, we haven't moved on to the right. The learned judge was wrong in deciding that the word stepchild was limited to situations where the parental couple were married or were separate partners. In coming to that decision, she was wrong not to adopt the approach in Fitzpatrick and Sterling Housing Association Limited, and wrong not to accept that A's relationship with RS, Mr. Seals, had all the hallmark of her being a member of Mr. Seals's family, and that a modern family relationship is not confined to legal or blood relationships. I accept that is wider
Absolutely.
than the way I have put it before,
Yeah.
my lords. But if anything, I have narrowed that down, not extended it.
But you may have narrowed down the definition, but it requires some facts to be found. That's the point my lord was putting to you. There is no factual finding that Miss Patel and Mr. Seals lived together as husband and wife. I mean, you have to accept that. There is no such finding. And in order for your definition to work, there would have to be such a finding.
I'm taking the point. I'm going to the judgment, and what we have in the judgment at page 80.
80.
80.
Yeah.
Paragraph 35. It's Her Honour reciting Islington's submissions. I think it's the fourth sentence, halfway through. There is no dispute that if one took a broad brush approach, says Miss Davis, stepping outside the legislation, Miss Abdelrahman could be called a stepchild, but not when she is within section 113.
But that rather focuses on the relationship of Miss Abdelrahman and Mr. Seals, which is how I read your ground 1. It's the appellant's relationship with the deceased tenant. Whereas now you're inviting us to focus on the relationship of her mother with Mr. Seals, which is a different question.
Well,
I mean, one can imagine a situation in which the mother's relationship with the deceased is quite remote, but nevertheless there's a very good relationship between the child and the deceased. And one can conversely imagine a situation in which the mother's relationship with the deceased is very close, but the child's relationship with the deceased is quite frankly hostile. Obviously not this case. So one does need to identify which relationship it is that falls within the modern definition of stepchild. Is it parasitic on the parents' relationship, which is I think now your case, or is it the strengths of the relationship of the child and the putative stepfather?
No, we say it has to be the former.
Yes, it's parasitic on the strength of the relationship between them.
Because the members of the family, as in section 113 and the policy, do not require, this is Islington's point in a way, do not require further investigation as to the strength of the relationship.
Yes.
If you're a child or a nephew or a niece and you've been living there for the previous year, that's it. You've got the right to succeed. There is no further investigation as to whether or not you had a relationship, and one thinks of the facts in Michalak, where he was not a member of the family. Yes. He was remote, but he was also remote in his relationship from the deceased tenant. He was at the cinema on the day that the deceased tenant died, and so forth. They led very separate lives. But 113 isn't about that. 113 is simply about specifying the categories.
Thank you.
And so whatever I might feel about the second part of my Lord's proposition, the nature of the relationship between, let's use the names for simplicity, Miss Abdelrahman and Mr. Seals, the starting point is the nature of the relationship between Miss Patel and Mr. Seals. And I accept that the grounds of appeal do not put that in as precise a way as I've put it today. And I take the point about that therefore raises difficulties with findings of fact. I take that point. But the principal difficulty that we have with findings of fact is that they were not explored, and that my client's factual case was accepted, and there was no submissions from Islington that even on the basis of her factual case, as a matter of fact, the relationship between Miss Patel and Mr. Seals did not amount to something that was sufficient for my client to be considered a stepchild. That was not an issue. And so yes, we have to put forward the whole of our case, but we did factually, and that point was not taken.
That's very clear.
I'm sorry, I'm just going back to my notes. I'm thinking that my lords and my lady probably do not want me to go through the facts, since the court has clearly a very good grasp of them. All I would say is that there is evidence in the supplementary bundle, and compelling evidence, we say, that one went to the nature of, that one went to her period of residence at the property, 24 Manger Road, for some 3 years or so before Mr. Seals had died. My lords and lady, in fact, have a small proportion of the amount of evidence that was before the judge. And the second is that there is evidence in the supplementary bundle from friends, neighbours, and Mr. Seals'
Yes.
biological family.
Indeed.
As to the nature
So
of the
we've
relationship.
seen all that. I'm sorry to go back
No, please do.
at
No.
round we've looked at before, but my understanding of your skeleton argument, paragraphs 25 and 26, page 26 of the core bundle, is that you were arguing for the online dictionary definition. But I don't find in your skeleton argument the more restricted definition that you've put before us this morning.
Well, paragraph 25, obviously the relevant point in the extract from the definition is the word relationship.
Yes.
A person who is related to another as a result of a subsequent relationship of a parent.
Yes.
Yes.
But you have narrowed that
I've narrowed it.
to a relationship as if they were husband and wife or civil partners.
Yes, married couple is the modern phrase. Yes.
Married
yes, yes, yes. And I've narrowed it because I'm aware of the issue that the judge flags up about the possibility of fleeting relationships.
Yeah.
I say that that's not a realistic possibility, because if there is a fleeting relationship, it would be extremely surprising that, so there is a relationship between a council tenant and somebody else has a child, that relationship is fleeting. It would be extremely surprising for the child then to have been living with the deceased tenant for a year before his death. So I say that fleeting relationships is a very unlikely occurrence, but I am aware of the point.
Yeah.
And the other reason I have narrowed it is because conceptually, given that, again, I'm going to say cohabiting partners for shorthand, but people who are living with each other as if they were married couples or civil partners, feature in section 86A as if they were spouses. In other words, they have the right to succeed regardless of the council's policy. And that is at page 10 in the authorities bundle. They have a right to succeed regardless of a council's policy, and they have a right to succeed if they were living with the occupying the dwelling house as their only or principal home at the time of the tenant's death, rather than a one-year residence. And that...
So on this basis, Miss Patel would not have been entitled to succeed, is that right? Because she maintained her own home in Luton.
It doesn't seem as though she was occupying as her only or principal home.
No.
But that was not explored in evidence. I don't want to make a formal concession to
No, I
her.
follow that.
But she didn't
But
apply
it
to
would,
succeed.
it would be odd if she couldn't succeed, but Miss Abdelrahman could.
We come back to the difficulty of the factual background of this case, which was not explored. But she did not, and she did not apply to succeed. It might not be that odd if a couple have two homes. Unusual for a council tenant, I accept, but happened in these circumstances, and could happen as a result of relationships that blossom later in life. Could easily happen. The partner of the deceased tenant is living with him, but is not occupying the council tenancy as her only or principal home. Her only or principal home is Luton. They live together in the two different properties. But the child, the stepchild's only or principal home, she's made it with the person she regards as her stepfather. That's not wholly unlikely, and it happened in this case. So that is the test for cohabiting partners. And I should make the point that cohabiting partners were inserted into the Housing Act 1985 and given the same status as spouses by Section 86A for tenancies starting on the 1st of April 2012. Prior to that, they were members of the family, and they had to fulfil the one-year residence requirement. And that, we find that in a number of places, not least in the case of Turley and Redbridge that my Lord Lewison referred to. And so I say that, accepting that I have narrowed the definition, but I say that that is the correct definition, conceptually and legally, in line with the treatment of cohabiting partners that came in from April 2012. And that one should therefore treat stepchildren in the same way, at least for tenancies from April 2012. If my lords and my lady are interpreting section 113 and interpreted in the way I contend for, then it will apply to all council tenancies, because it will apply to both section 113 and this policy.
Yeah.
And that puts everything on all fours. Can I deal with Islington Point against my grounds 1 and 2, insofar as we've not already dealt with them? I'm sorry. The first point made by Islington and adopted by the judge is that a stepchild in the authorities policy must be interpreted consistently with the case law that has interpreted section 113. And I agree with that. I agree that Islington made a conscious decision to apply section 113. And I say that we are not seeking to amplify or expand the categories of section 113. We're not in Michalak. We're not in Wall, where he was a foster child. We're not contending for a type of relationship that is not recognised in section 113 to come within section 113 or the policy. What we're doing is we are defining the word stepchild in both 113 and the policy. And I make the point that there has not been a consideration of the definition of the word in case law. Islington's next point is that all the matters set out at section 1132 are ascertainable with a piece of paper, as it were, that there is no evaluative judgment to be made. And they say that one can identify stepchildren on the definition that they contend for. In other words, where the biological mother or father, the biological mother was married or civil partnered with the deceased tenant, that is a simple matter. One just needs the birth certificate to prove the biological mother and then the marriage certificate to prove the marriage. And they point to Sheffield City Council and Wall, where I think it's Lord Justice Brooke says that Mr. Wall was lacking the vital piece of paper.
Justice Ward, I think.
I'm so sorry, thank you. Lord Justice Brooke is in Michalak, yes. Was lacking that vital piece of paper. We say that that's not the right interpretation of Wall. What Mr. Wall was lacking was the status of an adopted child. It so happened that the piece of paper would have confirmed that, would have been evidence of that status, but it wasn't the piece of paper he was lacking the status of an adopted child. In terms of the more general point about, well, this is a quick and effective way for a council to be able to ascertain relations. We acknowledge that it is, but we say that's not enough, and that's not a reason not to accept the definition that we contend for. And we say that councils do have to investigate and make complex evaluative judgments in matters of succession. They have to investigate whether somebody was living with the deceased tenant for the previous year. And where a partner, a cohabiting partner, applies to succeed, they have to investigate whether or not, under section 86A, the cohabiting partner was living with the deceased tenant as if they were a married couple or civil partner. So there are plenty of circumstances in which they have to do that investigation that doesn't depend on pieces of paper. So whilst I accept that if that applies to stepchild as well, they would have to do that, I say that that's not something that is wholly unusual for them. And there are ways of doing it, checking the electoral roll, council tax records and so forth. It's also not unusual in the broader area of social welfare policy. They have to do so in terms of their homelessness duties. The DWP has to do so in terms of cohabiting partners. It is something that institutions are able to do. And we also say that the piece of paper cannot be the whole answer, because if one looks at section 113 and takes, for example, a brother applying to succeed, the first question a council would ask is, produce your birth certificates, that of the deceased tenant and the brother. And if those birth certificates are produced, then that is an answer. They're brothers or they're not brothers. But it's perfectly possible that you may have two brothers who don't both have birth certificates, supposing they've come from abroad and they didn't have birth certificates or aren't able to produce them. In those circumstances, a council would not be permitted to say, well, we cannot consider your claim to succeed. They would have to make an evaluative judgment on the evidence that there was as to whether or not the person applying to succeed was the deceased tenant's brother. His account, relatives' accounts, friends' accounts, anything that would be corroborative, and they would have to come to a decision. They could not simply turn somebody away on the basis that they didn't have the birth certificates. And similarly, if the matter then went to court, because under section 113, the court has a primary fact-finding jurisdiction, they're not bound by the council's decision. That's under the old law. There is a separate question about whether that would apply under a policy point. But under the old law, certainly it was for a court to decide if the local authority had refused succession on the basis that, for example, you are not the person's brother. The court would make its own decision. So we say that the piece of paper point, whilst obviously useful for administrative convenience, is not a whole answer. Islington say that we are in different territory to the territory of the House of Lords in Fitzpatrick and Stirling, because, of course, in the Rent Acts do not define a member of the family, whereas under the Housing Act we have section 113, which contains the categories of people who fall within the member of the family, and they say that the only relevant question is the factual one of whether Ms. Abdelrahman is Mr. Seal's stepchild. We agree, but we say on the basis of...
Yeah, I mean, it's common ground that section 113 is what's been called a closed list.
Yes, yes. And we're saying we're simply defining
Yeah.
one of the words in that list. My lord has the point. And they say the purpose of the authority's policy is restrictive, not expansive. The same point applies. We simply say that we're defining the word here. We're not extending it. They also say that it would be unjust for Miss Abdelrahman to have a better claim to succeed than Mr. Wall. And we say that's not a good comparison. Mr. Wall was a deeply sad and sympathetic case. But it cannot be right to hold his circumstances of being a foster child who lived with his mother for indeed most of his life. I think 33 years I calculated, with a short period of studying and working, and then came back to live with his mother for the last year of her life, but was not adopted. It cannot be right to hold him up as one side of the line who is not entitled to succeed, as against, in terms of sympathy, and in terms of what is the right decision about member of the family, because a number of the categories in section 113, a nephew or a niece or an uncle or an aunt, for example, are conceivably a much more distant relationship with the deceased tenant than Mr. Wall was with his mother. He fell on the wrong side of the line because he was not adopted. A nephew or a niece would fall on the right side of the line, providing they had been living there for 1 year, no matter what the quality of their relationship. No reason for them to have been brought up by the deceased tenant as Mr. Wall. So we say Mr. Wall is unusual, and it's wrong to make that comparison. Would my lords and lady give me one moment?
Yeah.
So on the grounds 1 and 2, you have my submissions. We ask you to define stepchild
Yes.
for the purposes of section 113, which we say in this case must therefore apply to Islington's policy. And we say, given that there is no definition in statute or authority, if that is the role that the court undertakes and decides to do so, then in coming to what is the right definition, the court has to apply the approach by Lord Slynn in Fitzpatrick and consider what would be, in Fitzpatrick it was the definition of member of the family. We say stepchild. What is the definition of a stepchild nowadays in 2025?
Well, why 2025?
Well,
Surely it would be 2021 when Mr. Seals died.
21st century, 2021. I'm happy with.
I mean, that's the
2021.
latest
Yes.
possible date, isn't
Yes.
it?
But not in 1985, when the Act was passed. Lord Slynn compares the definition of members of the family under the Rent Act. I take the point about the difference, but the definition of members of the family under the Rent Act in terms of same-sex partners, between how people might think in the 1920s and
Yeah.
how they were thinking in the 1990s. And we say that my lords and my ladies should take the same approach and consider what is the definition of a stepchild in 2021 or the 21st century.
Is it the date he died, or the date on which the tenancy was granted to him, or the date on which Islington adopted the policy?
These purposes, in terms of what is the modern approach to stepchild, then I don't, it doesn't matter.
Doesn't matter.
I'm not suggesting that there was a shift in attitudes between if the policy is adopted in 2013, the date of the tenancy in 2015, or the date of death in 2021.
But you do say we don't go back to 1985 when the Housing Act was passed. Whatever stepchild then meant,
Which we don't know.
which we don't know, and of course, Section 86A wasn't there
No,
in 1985.
no, it's Section 87, yes.
Once Section 86A comes in 2012,
Yes.
you say that colours the meaning of stepchild thereafter.
We
is
have
that-
a very clear definition in Section 86A in 2012.
Yes.
Cohabiting partners, again,
Yes.
that's my loose
Yes.
word. The precise definition is at subsection 5 of Section 86A.
Yes, I see.
And so I'm content, in fact, in terms of the point of time and what is the modern approach to stepchild, I'm content to say, as of 2012, the modern approach to cohabitation is the definition in subsection 5, and one should apply that.
That's very helpful. Thank you.
This is a slightly mischievous point,
Yes.
Davis, but the notion of cohabitation might be thought to imply living together in the same place, and to the extent there's any evidence in the witness statements about that, the evidence suggests that the tenant's mother and the tenant were not cohabiting. The tenant and the appellant may well have been cohabiting, but it doesn't look to me from the evidence as though there was evidence before the judge that the tenant and the appellant's mother were cohabiting at the relevant time.
They say that they were cohabiting at the two different addresses.
Well,
They moved from one to the other together.
yes, well, okay.
So they were cohabiting, and that we find.
No, I've looked at the witness statements. The point I'm making is a slightly different one, which is that the notion of cohabitation to me implies living together in the same place, but you say that's not right.
They were living together in two different places, but
Yes.
on the evidence, on their witness statements, then they were either together in one place or together in another place. And again, that's not unusual. Richer families who may have holiday homes would be cohabiting, whether they were in London or in Cornwall, as it were.
But if one looks at paragraph 19 of the mother's witness statement, that doesn't suggest. It doesn't seem entirely consistent with the picture you just painted. Around the beginning of 2018, the appellant moved in into the property permanently. I would travel regularly to be with him. She was now permanently looking after him.
I'm
It
looking
sounds like he
for.
was
I'm
in one
looking for. I would
place.
travel regularly.
It sounds as though he was living in one place and she was living somewhere else.
I'm sorry, I found yes. I accept that there are questions in the evidence to be teased out, and they were not, because it was accepted. And it was accepted that, as I say, quoting from the respondent's skeleton argument before this court, there was no substantive dispute about the nature of either the appellant's relationship with Mr. Seals or her mother's relationship with Mr. Seals.
Well,
Yeah.
that might beg some questions.
But I mean, I entirely accept that the fact that the evidence was accepted means that those questions have not been teased out. I entirely accept that.
All right, thank you.
And I'm sorry, this is picking up a point that's going back a bit. When you say adopt the Section 86A requirement, of living with the tenant, at what date is the council meant to test that? Is it the date of death? Or is it some other date?
May I come back to that at the end of my submissions? It is a very good point. I confess I haven't thought it through, and it needs a little.
Because one can well imagine, if we accept your submissions and that's what Section 113 means, it also inevitably follows that that's what Section 86A means. And one can well imagine there may be a whole variety of factual circumstances where this is might be an important question.
Yes, and I'm aware that's not been teased out, and
People's relationships these days come in all different shapes and sizes, particularly with second relationships. Sometimes people live apart, sometimes they live together, sometimes all the time, sometimes part of the time.
Yes, which is why I say that this account of a couple spending their time at two different addresses is not that unusual.
Well, that's one thing, but it's another thing where one of the partners lives in place A primarily, that's their home. The other lives primarily in place B, that's their home. Although they may well visit each other and spend time in each other's homes. That's not quite the same as
and that is not the definition of stepchild that I'm contending for.
No, I understand that, but
precisely because of the fleeting relationship problem.
Yes, but I think I would like to understand when it is that they have to be living with.
Yes, I will come back to that.
Thank you very much.
And I mean, my initial observation is that if they were married, it wouldn't matter.
But that's
I take
as we discussed before.
Lewison's point that is a particular status. Yes.
If you're married, you've got the piece of paper, and that
Yes.
really is a trump card. You don't need anything else.
Yes. Yes, but it's not you. It's not the spouse. It's the child of the spouse.
Yes.
If Mr. Patel and Mr. Seals were married,
It wouldn't matter how much
It
time they spent
No.
together or apart or where.
No.
But
No.
this definition you're inviting us to adopt does require
no, I see that.
focus on.
I see that, and I will come back to that.
Thank you.
Can I move on to the grounds 3 and 4, the human rights points?
Yes.
And of course, these arise if my lords and my lady are against me on the interpretation point. And Miss Salmon is absolutely right. The legal way to take it is ground 4 first, Article 14, and then ground 3, the Section 3 reading down. And I only get to ground 3 if I establish Article 14 discrimination under ground 4.
Yeah.
So I apologise for it being the
We'll
wrong
come
way
back
around.
to Section 3 because there's another point as well. But just stick with Article 14 for the moment.
Yes.
The judge concluded that the policy in the way that she interpreted it was a proportionate means of pursuing legitimate aim.
Yes.
I don't think it's suggested in your skeleton argument that she asked herself the wrong questions. She came to a view on proportionality. And as you all know from Zed and Hackney, it's not our function to form our own independent assessment of proportionality in a case where what is in issue is an allocations policy, which is what was in issue in Hackney. So you've got to identify some flaw in the judge's reasoning which undermines the cogency of her conclusion. Now, as far as I can see from your skeleton argument, the only potential flaw that you identify is that there wasn't evidence to show that there was a housing shortage in Islington. But any judge, any circuit judge sitting in the central London County Court will know perfectly well.
My lord one has to be a hermit, yes.
Yeah.
So, of course, I accept that. what I would say on my feet is that that's not the flaw, but the flaw is this. First of all, she starts at the bottom of page 88, paragraph 70.
Sorry, give me the page again.
Paragraph 80, page 88, paragraph
88.
70.
Yeah. Yes.
So the first flaw is her directing herself that the approach contended for on the statutory interpretation point would have meant an amplification of the meaning of stepchild. We say that it's a definition, not an amplification. She then goes on to justification at paragraph 71. So I should say on that basis, there isn't a point before the judge below about whether or not my client has a status that results in differential treatment. That is in the respondent's skeleton argument, and I can deal with that if necessary.
Well, she's rather assuming that your client does have a status.
Yes.
She's going straight to the
To go
last
straight
question.
to justification. Yes.
Yeah.
Yes. Two sentences on. In terms of status, I say that she's clearly in an analogous situation with the person whose biological mother was married to the tenant, and that is not a status that arises out of the set of facts before Her Honour and now my lords and my lady. It is a status that she carries whether or not she applied for succession. That's simply what I say on status.
Yeah.
If I may have to come back to that on reply.
But so whether your client has or doesn't have status may be a matter for argument in this court, but the judge below seems to have proceeded on the basis that she did. So that's not a flaw.
Yes. So what the judge does is of course she takes into account the wide margin of appreciation that should be given to a local housing authority.
Yeah.
Not a suspect ground, and it relates to areas of housing policy where it's been well established the court should be very slow to intervene.
Yeah.
And
Anything
then
wrong with that?
towards the bottom at 75, she relies on, at the bottom of 75, the point, yes, the local authority have to carry out investigations to whether the applicant has been living with the tenant for 12 months, but it's entirely explicable and objectively reasonable for them not to want to have to inquire into the nature of other relationship, which may be sometime in the past, either because one of the parents of the applicant has died or the relationship may have terminated many years ago. So on top of acute shortage, and it is for the local authority in a wide margin of appreciation, she picks up Islington's point about obtaining evidence easily. The piece of paper objectively objectively explicable, objectively easy to understand, easy to ascertain on the basis of a piece of paper. What I say she failed to take into account is a number of things. One is that this was my client's home. That's clearly before her because we only get into Article 14 if we have an Article 8 ambit, and that's accepted. And it had been her home by the date of the death for about 3 years.
But I mean, isn't that completely obvious from the facts of the case?
But it's not in the judgment. So
so she needs to say expressly.
well, she needs to be carrying out a balancing act, and the balancing act in justification and proportionality is entirely referring to the respondent's points.
Oh well,
So that
is that right?
Now,
What about-
my lords and my ladies, that wouldn't be enough.
no.
Just the home.
What about
clearly it wouldn't
paragraph
be enough.
73? The judge is saying, well, Parliament has struck the balance between housing need and family relationship in one place because Section 113 no longer applies. Islington's policy is more generous to family relationships than it is to housing need. This is the point she's making. Current legislation is much more limited.
More
So-
limited.
So
Yes.
you're saying that it should be even more tilted in favour of family relationships than the current policy, which is itself tilted more favourably to family relationships than the legislative scheme.
It's more generous than the minimum they need to do under Section 86A. It is not more generous than they were previously required under Section 87, and indeed continued to be required to all those tenants who had family members of tenants who had tenancies granted before April 2012. And one of the points is that, from Islington point of view, they will have wanted a degree of consistency between their different tenants, two people living next door to each other. My lord has the point that it would be unfair, and they're right, therefore, to adopt as their policy what was previously the statutory requirement. So she does note that they have done so, but she doesn't go any further than that.
Can it be relevant to the proportionality of the policy? We're not talking about the application in this particular case, because if the policy means what Islington says it means, they don't have any. She simply doesn't qualify. Can it be relevant to the proportionality of the policy that in your client's case she'd been living with Mr. Seals not just for the 12 months which the policy requires, but for a rather longer time? I mean, that can't affect the question, can it, of whether this is a justifiable policy?
So in terms of, well, the and therefore discriminatory, yes. So in terms of considering whether my client has been subject to Article 14 discrimination, then by application of the policy, the judge needed to take into account her home, the length of time. We say also, and I accept that this isn't a point that is not...
This is the point I'm having difficulty with, because
Yes.
you know, one can envisage a situation in which a person in Miss Abdelrahman's relationship with a deceased tenant had lived with them for 40 years.
Yes.
You know, their entire
Yes.
life.
Yes.
But it wouldn't affect, would it, the Article 14 question? Because the Article 14 question is not, am I being treated differently? Which, as we've said, the judge really accepts that
Yes.
she is being treated differently from someone whose mother had been married to the deceased tenant. But is it a justifiable
Policy.
distinction to draw between different people according to whether her mother was or was not married to a tenant? And that distinction is based, the justification that the judge finds is that isn't her entitled to have these quite bright line distinctions.
Yes.
Now, either she's right about that or she's wrong about that, but I don't see how, whether that is a proportionate policy or not, can vary depending on whether the applicant has lived for 12 months or 40 years with the deceased. I don't see that it affects the proportionality of the policy. Have I misunderstood
No,
your case?
yes. Can I come back to the policy? I do know that's the second question I have ducked. I do know that. But just back to the policy. What I do say, and this is not teased out in front of the judge. It's not in my skeleton argument. I accept that, but it must be implicit in the argument. Is that the reason for the differential treatment, the fact of the differential treatment, is the lack of marriage
Yes.
between Miss Patel and Mr. Searles. What is relevant to that, in terms of considering whether that differential treatment is justified, and it's 1 point, but it goes in the balance, is that that was not a decision taken by the stepchild. It was a decision taken by others, Miss Patel and Mr. Searles. And so in terms of Islington drawing its bright lines, deciding who falls on which side, and therefore differential treatment, whether or not the differential treatment has arisen because of a decision that one made oneself or decision that somebody else made, we say is relevant.
That's a different question.
It is,
but yes.
it is a different question. I was moving on,
Yes.
bit aware that...
In relation to that, many of the relationships which are listed in 113 and in the policy are things about which one has no choice. You don't choose who your siblings are. You don't choose who your uncles, aunts, nephews and nieces are. But almost the only relationship you actually choose is your own partner.
Yes, yes.
So I'm not sure that that's a very persuasive point in relation to a stepchild. If you're a child, you don't choose whether you're adopted or not. That's a matter for your adopted parents.
And one could make the point about Mr. Wall, yes, because it wasn't his choice to fail to get adopted, as it were. I see that. But given that what the differential treatment occurs because of the lack of marriage, rather than falling within a more distant relationship, such as that as cousin or what have you, that you didn't make any choice about. But here the differential treatment occurs because something that has come about because of her mother's decision and Mr. Searles' decision.
But the lack of a marriage has been said to be something which a national authority is entitled to take into account. And you've referred us to Yigit and Turkey, which I think was a Grand Chamber, and they say very clearly at paragraph 72, I think it is, that marriage is widely accepted as conferring a particular status. Protection of marriage is an important legitimate reason which may justify a difference in treatment.
It may.
It may.
Yes, and it also may in McLaughlin. But in McLaughlin, the Supreme Court found that in the circumstances of bereaved widows' allowance, that taking the lack of marriage into the balance, that it did not do so. So if Islington's case is, as part of justification, we take into account lack of marriage, for the reasons that my Lord has just said, they must also acknowledge that that was a decision not made by the stepchild.
Yeah.
Whereas in McLaughlin, of course, and in Yigit, both of those claimants, applicants, were the people themselves who'd made decisions about whether or not they were married. So we do say that is relevant in the proportionality exercise, and that Islington that the judge should have taken that into account. I accept that's not there. I do say that it's not there, but it is implicit. What we also say in terms of the point that the judge did rely on about the ease of ascertaining it, requiring no investigation and so forth, is one, that local authorities do make those types of investigation. I've developed that. And two, that insofar as Islington, the judge, might be concerned about abuse, that the 1-year residence qualification, which Islington have in their policy, replicating Section 87, as was, is part of the protection against abuse. Somebody can't just turn up and say, I was the
Yeah.
deceased tenant's stepchild, they have to show, and the burden is on them, they have to show that they were living there. And once they show that they were living there, then the council would start to think, well, this is potentially a family relationship and so forth. So that's an important hurdle to be able to overcome in terms of abuse. The final point I make on justification, two final points, is that there has to be a rational connection between the differential treatment, rational connection that relates to the differential treatment, and I do say what is the rational connection under McLaughlin between my client not succeeding and her mother and Mr. Seale's decision not to get married. Just on the children point,
Sorry, there must be a rational connection with the differential treatment, and what was the other thing?
I've not put it very well. There has to be a rational connection.
And what? Between the differential treatment and what? The legitimate aim, is it, or the proportionate means of achieving it?
So sorry, I'm finding the right. It's in Baroness's Hairs,
So we're in McLaughlin, are we?
which is tab 22.
Yeah.
And it's page 220, and it is the legitimate aim. The mere existence of a legitimate aim is not enough. There has to be a rational connection between the aim pursued and the means employed.
So which paragraph?
37.
37. Yeah.
And so I say that in terms of what is the rational connection between Mr. Patel's and Mr. Searle's decision not to get married and my client's inability to succeed under the policy. And at page 222, Baroness Hale is making the point. It does not follow that the operation, at the top of the page, paragraph 43, it does not follow that the operation of the exclusion of all unmarried couples will always be incompatible. It's not easy to imagine all the possible permutations of parentage, which might result in an entitlement to live as parents' allowance, the recent introduction to the household of a child for whom only the surviving spouse is responsible, whether it would be disproportionate to deny that child the benefit of the deceased contributions would be a specific question. So the point is made that in terms of justification and proportionality, what is relevant is the effect on the children as well as on the couples who made the decision not to get married. Lord Manx over the page at page 223, at the bottom of the page, paragraph 52, a policy in favour of marriage or civil partnership may constitute justification for differential treatment when children are not involved, but it cannot do so in relation to a benefit targeted at the needs and well-being of children. So there is a difference when, insofar as marriage being a legitimate aim, there is a difference in approach between those who made the decision whether or not to get married and those who are affected by the decision, the children.
But the legitimate aim in McLaughlin that was put forward was marriage is a good thing and we want to promote the institution of marriage. But I didn't understand Islington's case to be that we're trying to promote marriage as an institution. I understood it to be we have a very limited stock of housing, we're entitled to have nice, clear-cut categories of people who qualify under our discretionary housing policy, which is not, we think marriage is a good thing and we're trying to promote it. It's a different
point. And secondly, they go on to say, and one of the reasons for that is it's easy to ascertain.
Yes, exactly.
Yes. I accept that, and I say that the proper approach, which the judge should have done, was put into the balance that this is a child
Yes,
who didn't make that decision.
Yes,
I mean, McLaughlin was concerned with dependent children.
Yes,
not
And this is
adult
not-
children.
yes, I was going to say that, yes. And whether or not they could directly get a benefit on that basis, I understand that. My lords, can I move on to section 3, ground 3, and I can take this very simply. If my lords and my lady are with me on Article 14 discrimination, the question arises, what should this court do? It's clearly not appropriate to make any sort of declaration of incompatibility. And so one then turns to section 3 to read primary legislation on the basis that Islington put their policy on the basis of interpretation of section 113, to read primary legislation compatible with convention rights.
Section 3 you would accept doesn't apply directly to the policy.
No, it applies to primary legislation. I have to have that additional step.
Yeah.
That's how Islington put their case, that this is interpretation of Article of section 113. And I say, and it's very similar to my statutory interpretation point, that as soon as my lords and my lady are trying to read section 113 compatibly, then one has to take a modern approach.
Yeah.
And I rely on that, on the approach of Guyden and Godin Mendoza, where my lords and my lady are very familiar. They came to the conclusion that his or her husband or wife is read as applying to same-sex partners. So one can strain language if necessary. And Lord Nichols' speech is emphasises that discrimination is an insidious practice, and that therefore, in his case, in the case of Guyden, he says one looks in vain to find justification. And it's also the case that there is no need for legislation to be ambiguous for my lords and my lady to take a section 3 approach. So we say that once, if my lords and my lady are with me, that there is Article 14 discrimination, then the correct way to remedy that is reading section 113 down under section 3 as to include, as for the definition of stepchildren, to include the definition that I started with. May I come back to my Lord Nugee's point about the date when the relationship between the mother and the deceased tenant has to be concerned? And may I just turn my back one moment? So, my lords, we start with Fitzpatrick. I'm very grateful to my Lord Julia for helping me on that. We start with Fitzpatrick, which is at tab 17. And we'll go to Lord Slynn at page 51. That's at D. The point is made about how you define membership of the tenant's family. If, as I consider, this was the purpose of the legislation, the question is then who in 1994, which is where when the tenant died, or today, I draw no distinction between them, are capable in law of being members of the tenant's family. So from Lord Slynn doesn't decide the point, but it clearly, on the formulation I contend with, it clearly cannot be whether Miss Patel and Mr Searles were living together today, or at the date of Islington's decision, or at the date of the possession hearing. Clearly cannot be that. And so I'm content with that, the relevant date for assessment of their relationship as the date of death.
Sorry, I think your answer and my lord's question are addressing two different points. Lord Slynn, I think, in the passage you referred to, is discussing what member of the family means. My
Yes.
lord's question, I think, was, when do you test the facts
Yes,
of the
Yes.
relationship?
yes.
So they're two different, unless I've got in a complete muddle.
No, I think I agree.
Um,
You started
Yes.
this morning with a very helpful definition of what you are contending for,
yes,
drawn from section 86A, and it is that the child of a biological parent living with the deceased tenant as if they were a married couple or
Yes.
civil partners.
and your question
And my
was
question is, when do you test that?
the
Are
living
they,
with.
are they
Yes.
living with?
Yes, I understand that, yes,
As a question of fact, and
Yes.
your answer, I think, is the date of death.
yes.
Yes.
Because Lord Slynn, in that passage, he said, what he's saying is it's not 1920,
Yes.
and he then goes on to say it could be 1994, which is the date of death, or it could be now. So I draw my lord's and my lady's attention to that. Clearly it can't be post the date of death, so I say it must be the date of death.
Thank you.
Would my lords and my lady give me one moment?
Yes, of course.
Unless there's any other matter that I can help. I'm grateful.
Should we go out for a minute? We'll just rise for a minute, see where we get to. Don't leave the courtroom. We'll be back very shortly.
We'll rise if able.
YouTube is probably still on, so this one is on.
Court rise if able.
Ms Salmon, we needn't hear you on Article 14 or Section 3. We would like to hear you on the question of the definition of stepchild that Ms Davis has put forward. And there are two aspects of that question. One is it open to Ms Abdelrahman to put forward that definition, bearing in mind the way the case was run below? And secondly, if it is, what's the answer to it?
My lord, thank you. Can I just make it clear that Miss Davis sat behind me was going to do the Article 14 submissions in
Right.
line with the guidance issued by the court in November. So I
Yes.
do.
Well, I'm sorry that
just
we
want
have
to
shot her
acknowledge that,
fox,
and you
but
won't
there we
be
are.
hearing from
Yeah.
her, which is a shame, I'm sure. I was the one that was going to be dealing with grounds 1 and 2, and obviously there's some clear overlap. I hear what you want to hear me on. Can I just address this issue of interpretation of policy? My learned friend referred to Newham and Ahmed
Yes.
as a case. Can I just deal with that very quickly? As set out in our skeleton argument, it is, of course, for a local authority to create allocation schemes in accordance with the various statutes that govern them and dictate what can and cannot be in there or left out. And, you know, one part of that is succession, another part of that is reasonable preference under Part 6. The Newham and Ahmed case was a Part 6 reasonable preference case, and about whether or not it should apply to people who have been detained. I don't read that case as saying that the court can't get involved in interpretation if there's an issue about the words. It is for a local authority to create the policy. It is plainly for the decision maker under the necessary part of the policy to apply the policy and come to a decision. But if there is any question over a meaning of a word, be it within the policy or how it's being framed here under statute, then the Islington's position is that the court can look at what those words mean. So I don't read Ahmed quite in the same way as my learned friend did. And of course, Tesco and Dundee, which my lady you referred to, I think my lord you referred to it, you gave the name of the case, of course says that at paragraphs 19 and paragraphs 18. So it's the context of the policy which is for a local authority, but I do think the courts can be involved in interpretation, and indeed that's how we framed our skeleton argument in terms of looking at the words. So I just wanted to address that point. And so if I can go back to, my lord, what you've asked us to address in the meaning of stepchild. First of all, I just want to come back to the workings of the statute and the policy. It is plain to me, reading Her Honour Judge Bloom's decision, and there's a number of paragraphs within that decision, that she keeps it clear in her mind that whilst the London Borough of Islington did make the submission that the policy was based on what was found in section 113 and no longer applies to that, what the London Borough of Islington also did, of course, was refer Her Honour Judge Bloom to the case of Wall. Why did Miss Davis, who appeared before the court, do that? She did that because our policy makes reference to the case of Wall, and that gives an indication of what the local authority's policy was intending to do. And if I can just take you to the policy, page 48 of the supplemental bundle, the reference to Wall isn't in terms, they don't cite.
Yes, they say recent case law.
But they say recent case law, and they specifically refer to a foster child,
yeah, absolutely.
and that's the only case that I'm aware of. And when you read the sections of the judgment, which my lords and my lady you've already taken the appellant's counsel to, it is plain that the submissions about the meaning of the policy were made in relation to both section 113 but also the case law, because our policy specifically referred to a particular piece of case law that had been decided. I confess my response to the grounds for today were premised on the basis of what was before us, and obviously Miss Davis' case has come into court today and adopted a different definition. It was going to be part of my submissions that the most obvious thing for Parliament or Islington to have done within their policy, if they were going to expand the meaning, and I do make the submission it is amplification and expansion, would have been to link it to people living together as if husband and wife. That would have been the most obvious way Parliament could have done it. And although you've not been taken to it today, my learned friends have relied upon various other statutes, and what that demonstrates is when Parliament has wanted to do that, they have done it.
Yeah.
And just while I'm on this point, just to correct another point, Section 86A, of course, only applied since April 2012, but Section 113 hasn't. Section 113 has been in the same terms since 1989, and you've got the different provisions in relation of 113 in the authorities bundle, and you can see changes have been made to it, but nothing has been added to stepchild. If I can just, one moment. And it is stepchild, I say, with which we are concerned. So it's paragraph 14 of the authorities bundle.
Just before we get there, can you address the procedural point that my Lord Justice Nugee put to Miss Davis? This is not the way the case was argued below. We don't have a factual finding that Miss Patel and Mr. Seals lived together as husband and wife. It is said that evidence wasn't disputed, but we don't have an agreed statement of facts. So what is the procedural position, given that the new definition for which Miss Davis argues takes as its foundation a factual assertion that the couple in question were living together as a married couple, as if they were a married couple or civil partners?
Well, there are
At the date of death.
Well,
which is
I was going to come to that, because if the appellant's position is that it has to be drawn from Section 86A, then I don't see any need to go to Fitzpatrick as to when the date is, because what 86A tells you in relation to a cohabiting couple or someone living as if husband and wife or civil partner is that it's at the date of the death. So if this definition is being linked to, in some way, Section 86A, the meaning of stepchild within Section 113, or well, actually, the meaning of child, so as to include a stepchild in Section 113, then it strikes me that that's where you find guidance as to what date you would be assessing the situation from. But the court is in some difficulties. A lot was made of Islington accepting the appellant's factual position. My lord, you've already taken the appellant to various pages. It is right to say that in the defence at paragraph 4A, it was pleaded the defence on page 95, the supplemental bundle.
Sorry, we're going to supplementary.
Yes, I think it's the supplemental.
It's a core bundle.
Oh, sorry, core bundle. I'm on
Call 95.
page 95. I mean, this is a paragraph, my lord, that you've already taken my learner from two. And it was pleaded in those terms, and as I think it was my lady highlighted, it's pleaded in the terms that she later ceased to reside at the premises. The court hasn't yet gone to the claimant's reply. The relevant passage is on page 91 of the core bundle. It sort of goes forward instead of backwards in the bundle. But they were put to proof on that. Now, whilst I accept no evidence was called at the trial, as my lords and my lady have already highlighted, that's because this was not an issue at the trial. The trial was all about the relationship between the appellant and Mr. Seals. It had nothing to do with Miss Patel's relationship with Mr. Seals and how that in some way impacted upon the respondent's position. So I do say you have to look at the case in that light. So there are no findings which assist. I mean, we made the point in our skeleton argument, even if that was, you know, this is a case where Mrs. Patel would not have succeeded. She was not living, or there's at least a question. I can't say she wasn't because there was no factual finding, but there is clearly a question of whether or not she was living as if husband and wife with Mr. Seals as of the date of his death.
Well, I think Ms. Davis accepts that if we allow her to run this point and she succeeds on it, it would have to go back to the county court for.
Well, I disagree with that slightly as well, because of course it's a decision under our policy, so it needs to go back to Islington for that case to be put forward, for Islington to reach a decision under its policy. There would then be possession proceedings if that decision went against, and then it would be run as a public law defence as part of the possession proceedings, it seems to me, because this has never been a factual situation put before Islington. But the short point is, in my mind, that it's whether or not there's been an amendment of the grounds of appeal, the policy just doesn't say what they want it to say, and it could easily have said that, and Parliament could have easily have said that as well in section 113, and it does create a whole host of difference. My lords, you've already asked some questions, but whose relationship are we considering? Are we considering the relationship between the child and the de facto, the treated as stepchild, step-parent? Are we looking at the relationship between the partners? How long and enduring does the relationship have to be? There's a reason, and my learned friend made the point about we have to investigate in relation to cohabiting couples. But if I can take you to Gaydon and Gaydon Mendoza at paragraph 13 on 125, and of course this was a Rentac case, and you'll have all the points in relation to Rentac cases from our skeleton argument. But this is the paragraph where they ask, what is the rationale for the distinction between married couples and cohabiting heterosexual couples on the one hand and other members of the tenant's family? And the rationale seems to be, for the purpose of security of tenure, the survivor of such couples should be regarded as having a special claim to be treated in much the same way as the original tenant. The two of them made their home together in the house in question, and their security of tenure in the house should not depend upon which of them dies first. So it's okay, Islington would say, to have to investigate where we're looking at someone if they are living there as if husband and wife, because Parliament has made a decision that they're afforded a different definition and a different status. What Parliament and Islington within its policy has not done is gone on to define child any further than the words you find in the policy. And there's been no amendment to the ground, but if what is being suggested, which is not clear from the papers prepared, but it must be being suggested that Her Honour Judge Bloom has erred in interpreting it in such a way that doesn't take into account section 86A, and in that sense, if that is the nature of the challenge, then in that sense this court can look at whether or not that was an error of Her Honour Judge Bloom. Whether or not then words have to be read in later, I'm not addressing you on that, but that must be how the case has to be put, and we say Her Honour Judge Bloom got it right for all the reasons she sets out on the arguments before her. But even if these arguments had been before her, I simply don't see how that assists the appellant, because the appellant's mother wasn't living, in her own defence, wasn't living with Mr. Seals as of the date of his death. I don't know if I'm answering the question, I'll be honest.
Well, I think one of the questions I asked you was effectively a procedural question. Given that we don't have the factual findings that would support an assertion that Miss Patel and Mr. Seals were living together as husband and wife, there are some statements in the witness statements to that effect, but there are other statements pointing the other way. But given that we don't have the judge's findings,
Yes.
do you or do you not object to this way of putting the point for the first time in this court being run?
Sorry, if I'm just gonna. My learned junior helpfully guided me, and hopefully the court, to page 7 of the core bundle. Which is the appellant's notice, because of course the section 3 ground was a new ground.
Yes.
And so, and they were obviously given.
Yes, well, that's a
permission.
question of statutory construction. And I can see why Lady Justice Andrews permitted that to be run.
But I think that's on page 7 the test is set out.
Page
There's
7.
a citation from Singh and Das,
Singh and Das,
which
yeah.
is the
Yes.
authority.
And in these circumstances, for all the reasons my lords and my lady have highlighted, we would object because it would call for evidence.
Yes.
And as I said already, if the court goes down this approach, despite that objection and the findings of Your Honour Judge Bloom, which you've already communicated to the relevant paragraphs, then the answer isn't it goes back to the county court. That's my alternative submission. The answer is it would be for the local authority to come to a decision based on the interpretation you say should be applied to their policy when they're looking at who qualifies as a child and a stepchild thereafter.
Right.
So. My lords, does that now answer your
It does,
question?
thank
So
you.
grateful, thank you.
Miss Davis, do you wish to reply?
My lords, I take the point, and clearly it's been refined as this case has progressed. I entirely take that point. Two things to say. One is that, and I'll come back on the issue about objection. In terms of the judgment and findings of fact, it is helpful to note the judge's finding at page 74, paragraph 3 of the judgment, about the narrowing down.
Yeah.
Where she says the issues narrowed considerably as the factual issues were no longer disputed, no witnesses were required to give evidence. The two issues remaining are whether the London Borough of Islington adopted a restrictive approach as to who is a stepchild, thereby erring in public law, and if not, was there discrimination. So they become the two legal issues, and what is not discussed, let alone teased out, are the matters that we've been, as it were, teasing out today.
Why?
I take the point that the definition I am contending for has been refined today. I do take that point. But what we've done is narrowed what was previously a much looser definition, where we said in grounds 1 and 2 that the learned judge was wrong in deciding that the word stepchild was limited to situations where the parental couple were married or were civil partners. So we said what was wrong. We said that it shouldn't be limited to that. And we didn't address in the grounds what the alternative would be. I accept that. But clearly the alternative can't be open-ended. Stepchild can't apply to anybody who's ever met the tenant and who might be younger than them or whatever. So there has to be something that narrows that down, and we've done that today. We say at ground 2, we make the point that what we're contending for is an interpretation of the word stepchild. And we say the appellant's submission was an interpretation of section 113 and of the respondent's policy, not an extension of it. So I accept I've narrowed down today refined today what grounds 1 and 2 say. I do accept that, but I say that's necessary in order to consider the point.
Well, yes, but what you say in your ground 1 is that the judge was wrong not to accept that the appellant's relationship with the tenant had all the hallmarks of her being a member of his family, and that a modern family relationship is not confined to legal or blood relationships. So what you're concentrating on in ground 1, on a straightforward reading, is the relationship between Miss
Abdelrahman
and Mr. Seals, not the relationship between Miss Patel and Mr. Seals.
Well, no, with respect, because one can't. I mean, yes, in that her relationship with him was as a member of the family, but as a member of the family isn't enough, because section 113 is a closed category. It is about the definition of the word child, including stepchild, and so in B, in ground 1, the modern family relationship is not confined to legal or blood relationships. Well, the not confined bit relates to Miss Patel and Mr. Seals' relationship. Clearly it does, because my client has a blood relationship with her mother.
Yes.
And would not have, the only basis in which he'd have a legal relationship with Mr. Seals is if the mother and Mr. Seals are married.
Yeah.
So we do say it's implicit in there. Can I make another point? My last point, which is about Miss Salmon's point about disposal. And again, this is a refinement of how both parties approached it in the pleadings and in the trial, because I understand Miss Salmon's point that this was a decision made under our allocation scheme, and therefore it's not, as the old approach used to be under section 87, for the court to make a decision about whether or not somebody fulfills the criteria of section 87 or section 113. It's for Islington to do that, and we can only be informed on public law. I understand that, but that's not how the trial before Her Honour progressed. It's not how the defence does refer to public law grounds. The reply puts my client to proof as to residence, nature of relationship, and so forth. Ms. Salmon took you to it, and so the submissions before the judge were, one, they were going to be on the basis of evidence, but that was then accepted, and as the judge says, that the issues have now were narrowed down, and then 2, they were, as she says, on the statutory interpretation of section 113. So they weren't judicial review points.
Yeah. Can I put this to you, just to clear my own mind? Your client applied to Islington to succeed.
Yes.
Islington, applying their interpretation of the policy, said, you can't.
Yes.
They then served notice to quit on everybody in sight, and they brought proceedings for possession,
Yes.
which your client defended.
Yes.
And let us suppose that your definition of stepchild is correct,
Yes.
that Islington therefore failed to apply the policy correctly. That would mean, would it, that Islington were not entitled to possession because they hadn't properly applied their policy?
Yes.
With
Well,
the result that the possession claim would be dismissed,
the possession claim would be dismissed.
and your client would then reapply to succeed? Well, how does it actually work?
So the starting point is as my lord knows, public law defences are available to possession claims.
Yes.
So matters that would form the basis of judicial review can be brought up as defences to possession claims. And at that point, the judge is in the equivalent position to the administrative court judge.
Well, and that's my question. In a possession action,
Yes.
is the judge in the equivalent position of the administrative court, in the sense that she can, so to speak, quash the decision and send it back to the local authority, or if she comes to the view that the public law defence is made out, must she simply dismiss the action?
Yes, and that's what happens. And off the top of my head, I'm trying to think whether she would have a quashing power under the CPR, and I don't think she would.
Well, the CPR, no. I mean, she is trying a possession action.
She's trying a possession action, so I don't think the quashing of the decision is available to her. But what is available, if she takes the view that the public law challenge is made out, is a refusal of the possession claim,
Yes.
a dismissal of the possession claim,
Yes.
which of course leaves the person in the property,
Yes.
and that.
But it doesn't give them a tenancy. She's
No,
not
of course
deciding
not.
that.
No, it doesn't.
So the
Yeah.
What is their status? They're a tolerated trespasser.
They are, yes, not in the old sense, which was about suspicion.
Yes.
Yes, they are there under some sort of license whilst Islington considers the position, or one could have, if nobody took any action, they would just sit there. They'd pay use and occupation charges.
She's paying the weekly.
She is, yes. There's an issue about a small amount of arrears at some point, but it's a couple of £100. It's not. It's clearly she's been paying. So and housing benefit is available for that and so forth.
So it would be up to Islington.
It would be up to Islington then to remedy the situation, and the starting point for them to remedy the situation would be to take a new decision.
Yes.
On the basis of whatever the judge had directed, their legal error was.
Yes.
And then there's no authority.
Either they would decide that she did fall within the policy,
Yes.
in which case they would offer her a tenancy, or they would decide that she didn't, in which case they'd start again with a
They
new
would
notice
start
to
again.
quit.
Yes. Under the old law, under Section 87, which still applies to the pre-April 12 tenancies, it wasn't about public law issues because there was
Because you have a statutory right.
because there was statutory right, and therefore the judge could be the fact finder.
Yes, I see.
But certainly under Section 86A in the policy, then to a certain extent I agree with Miss Salmon that is the right approach, that it is about a public law defence and it's about Islington taking the decision again. But the difficulty in this case is that's not how it was put to the judge.
Well, I understand that, yes.
Essentially the judge was being asked to do what she used to do, which was to make initially findings of fact, but they then got accepted, and then to make decisions on the law. So that is the rather strange position that we're in, and difficult position.
If a judge sitting in the county court is faced with a public law defence, presumably she doesn't have the same power that the administrative court has of saying, well, I can see there's a flaw, but if they'd done it correctly, they would have come to the same conclusion anyway.
No.
Section 31. That's not available.
No. She has a blunt instrument.
Yes.
You allow the possession claim, or you dismiss the possession claim.
Yes. Well, that's the only issue before her, possession or not.
Yes. It may be that she adjourns and makes trenchant remarks, something like that, if she wants to achieve a particular outcome. But
so you could,
what is available to her is allowing the claim or dismissing it.
Well, it's probably unnecessary speculation, but you could in a particular case say, well, I think you've misconstrued it, the true construction is this, but I'm now going to adjourn the possession proceedings for you to decide again, and then you can come back and see where we are. You could, and there may be arguments about whether that be said the right thing to whether that's a proper use of adjournment powers. But that would be the only power. Yes, I see. Short of dismissal or allowing the possession claim. I'm being, if I may. What's the answer? I'm very grateful. My learned junior, there's a case of Barber and Croydon, and it does two things. So that was a public law defence, and it says two things. One is the point that I just made: what is available to the judge,
Sorry, what's the name of the case?
Barber, Barber and Croydon. And it's 2010 EWCA Civ 51,
2010
EWCA Civ 51,
51.
51,
Yeah.
and 2010 HLR 26. And I'm told by Mr. Gannon, I'd have to go back and look at it, but it also deals with what one might call a potential res judicata point. In other words, that there isn't a res judicata point. In fact, so if the possession claim is dismissed, a new decision is made, a new possession claim is brought, there isn't a res judicata point. That's what I'm told. I haven't looked at it directly this morning.
Right.
Is there anything else? Anything else that I can help my lords and my ladies with? I'm
No,
grateful.
thank you very much,
Thank
Ms.
you.
Davies. Well, thank you both for your interesting arguments. We will reserve our decision. You will get a draft judgment or judgments in the usual way. That will be your opportunity to correct our English, but not our reasoning, nor to introduce new points. The draft judgment will come with a strict embargo on who can see it, and it means what it says. In the light of the draft, we would hope that you would be able to agree an order disposing of the appeal. But if you can't agree a form of order, please make short written submissions, and we will make the form of order that we consider to be appropriate. When the judgment is finalised, it will be handed down by publication to the National Archives and electronic distribution to those on the distribution list. So there will be no need for any further attendance. Thank you very much.
Grateful, my lords.
Rise and able.